Hello and welcome to Mayor Brown's webinar on how to navigate international arbitration in the Americas and Europe. I am Soledad O'Donnell, a partner in Mayor Brown's Chicago office and a member of the Litigation and Dispute Resolution practice. Joining me today as co-presenters are partners Raid Abu-Manneh and Alejandro López Ortiz. Raid is a global co-head of the International Arbitration Group and head of the International Arbitration Group in our London office. Alejandro is a partner in Mayor Brown's Paris office and leads the Latin American arbitration practice of the firm. Before we begin, we'd like to mention a few housekeeping announcements. First, as noted under the FAQ widget on the right side of your screen, today's program is being streamed through your computer, so there's no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presentation. Let's get started. And now I'll turn it over to my partner, Raid.
Many thanks, Sol, for this presentation, and welcome all of you to this webinar on Mayor Brown's. It's part of Mayor Brown's Global International Arbitration Series. As Sol said, the purpose of the webinar is to look at how to navigate international arbitration in the Americas and Europe. Indeed, a very wide subject and covering a vast amount of countries. But we are what we have done at Mayor Brown in order to assist everyone navigate so many countries and navigate international arbitration. Is we have devised a Mayor Brown Global Arbitration, International Arbitration Guide. That is available on our website. It's an incredible effort by so many people, particularly many lawyers across all of our different offices, that collated a vast amount of information in relation to the different regions. And as you can see, we've got the guide is split into the following: the Americas, Europe, Africa, Asia Pacific, and the Middle East. And today we are focusing on the Americas and Europe. We have a total of 159 countries covered by the guide, so we've collated information on 159 countries, which is I can assure you, no mean feat. Many people have spent many lengthy nights putting together all of this information. For the Americas, we have 21 countries. We have 33 countries in Europe. We have 49 countries in Africa, 37 countries in the Asia Pacific, and 19 in the Middle East, a total of 159. And the way we've gone about collating this information is in a way, whilst it's lots of hard work, but made relatively easy by the fact that Mayor Brown's Global International Arbitration Group is spread out across the different jurisdictions, and so working with everyone and my partners and colleagues across Mayor Brown's Global International Arbitration Network, we managed to put all of this information together. Well, we'll just give you a bit more details. What does it cover? It covers New York Convention status, absolutely very vital for you for the purposes of enforcement. It covers whether there's an ICSID convention in place. It looks at local arbitration institutions, plus identifies local arbitration laws, and then it looks into whether there's any bilateral investment treaties that are in place, and finally, well, how many ICSID cases. That's a very interesting guide as to a country's treatment of investors. Well, it could be a guide by the number of cases that you find in relation to a particular jurisdiction. And here you can see a snapshot of what our international arbitration guide looks like. You can see we've picked out Germany, a country that we have a couple of offices in Frankfurt and Düsseldorf, and you can see, well, when they entered, they ratified the New York Convention. That was in 1961. The ICSID Convention in 1969. Their local arbitration law. It looks at their local arbitration institutions. When the number of ICSID cases that they have, 23 concluded, 23 pending, so quite a number of cases. And you can see the bilateral investment on your right-hand side. You can see the bilateral investment treaties that have been concluded and some of the ICSID cases as well that are pending on the right-hand side. Now, looking at the latest survey on global international arbitration, you can see that, luckily for us here in London, that London is the most preferred seat, with 64% of people in favour of London. The LTIA, based here, although an international arbitration institution, is the second most popular institution. Paris is not so distant, sort of 11% difference, I suppose, is 53% who participated in the survey identified Paris as the most preferred seat, but the ICC remains the most popular institution, and Alejandro López from our Paris office will be telling you quite a lot about the ICC and the number of cases they have, etc. But in terms of New York, and my colleague Soledad will be telling you about New York. 22% identified New York as their preferred seat. So London remains by far the most preferred seat for the purposes of conducting an international arbitration, which is not surprising because it's sort of in line with how London is perceived, the fact that London is a global center, financial center in any event. So it's consistent with everything that we know, and so we will look into potentially what the impact of Brexit could be on London. And looking at institutions in Europe, I'm sure a lot of them will be familiar to you, but we've spoken about the London Court of International Arbitration. It's had 285 arbitration referrals in 2017. It's been in existence for a very long time, since 1883, so it's well established, no doubt. There is a perception, I think, that the London Court of International Arbitration is very much a sort of a London institution rather than an international institution, whilst the ICC is perceived to be more international. However, as you can see from the statistics, 80% of cases of parties were from outside the UK. So the LTIA, contrary to perhaps some belief, is very much an international institution and not very much London-based. Arbitration institutions, the Stockholm Chamber of Commerce, it had 200 cases. It remains extremely popular as a neutral place for international arbitration, particularly with parties coming out of the Russia and the previous USSR. So lots of arbitrations, and of course Scandinavia get conducted at the Stockholm Chamber of Commerce. And so 48% of their cases are international, but it remains a very prominent center and one of Europe's leading international arbitration centers. Germany has also its own leading international arbitration institution with DIS, with 125 cases in 2017, 44% with one or more international party. Although, as you can see, a lot of the cases that it does have are on the majority are more domestic. The Permanent Court of Arbitration, I won't dwell too long on that, but it's primarily deals with public international law cases, and it's had 97 investor state arbitrations in 2017. As you can see, there's a wealth of international arbitration institutions in Europe, no doubt. Also, the Swiss Chambers of Arbitration is very well known, with many years' experience. We have also the Vienna International Arbitration Center, and finally a new center now being created in Scotland, the Scottish Arbitration Centre. So, looking at arbitration awards in the United Kingdom, I can tell you from my experience over many years, it is an incredibly straightforward process to enforce in New York Convention award in this country. It requires no more than taking a copy of the award, the contract, and making quite a simple application to the court, the commercial court in London, for enforcement. An award, provided the form is there and the requisite evidence is submitted, a short witness statement, usually with an application. An award is from New York Convention countries is instantly recognized in England, and therefore usually once that's done, the other party gets notified that there is this award that has been recognized, and the party is given 28 days to essentially challenge the award. So the award is given instant recognition in England through, I'd say, straightforward, fairly cost-effective process, and then it puts very much the burden on the other side for a challenge. And the challenge of an award has to be done in accordance with the Arbitration Act, which provides for three possibilities of challenge, which are intended to be consistent with the New York Convention. The first being a challenge in relation to jurisdiction. The second is in terms of if there was an irregularity in terms of the procedure, in terms of the process. And finally, on a point of law. Now, most arbitration rules exclude a challenge based on a point of law, because it's a challenge under Section 69 on a point of law is non-mandatory, and therefore the rules essentially would exclude a challenge under Section 69. So the LCIA rules and the ICC rules. That only leaves if you've got institutional arbitration rules, that would only leave a challenge based on jurisdiction or a procedural irregularity. And I can tell you that the English courts take a fairly narrow view in terms of the challenge of awards. My colleague and I, Alejandro López, who you will be hearing from him shortly, we had an award. We enforced an award against Libya many years ago, and the process was incredibly straightforward, and the English court was very much in favor of enforcement in accordance with the New York Convention. And here in the slide, you can see the statutory provisions which incorporate the New York Convention. I mean, there's a sit-in here in this presentation, essentially for your reference. But as you can see, a specific incorporation of a New York Convention award may, by leave of the court, be enforced in the same manner as a judgment or order of the court to the same effect. So you can see the machinery by which a New York Convention award is actually incorporated into law as if it is a court judgment. And that's also referred to in Section 66 of the Arbitration Act. So very much the Act, which is based on ancestral model law, is very much in favor of arbitration and very much in favor of enforcement. And for this reason, perhaps London remains the most favourite seat for enforcement, although my colleague Alejandro, no doubt, and Saul will be talking about the virtue of Paris as a place and New York. So I'm sure you might hear a different perspective from them. In this slide, just a short summary of Section 44 of the Arbitration Act, which sets out the court powers exercisable in support of arbitral proceedings. But particularly, I think worth noting is the court's power to grant interim injunctions. Why is that significant, and why is it important to note that? London, as you know, is well known for a process called anti-suit injunctions. What does that mean? That if you have an arbitration clause with the seat, which provides for the seat in London, in England, and in another jurisdiction, there's an attempt to start parallel proceedings in respect to that particular dispute resolution clause, then the English court would, subject to their discretion, would issue, in most circumstances, would issue an anti-suit injunction basically against the party breaching the arbitration clause. So the English court is proactive in a sense in its support of international arbitration in terms of issuing processes in order to prevent a breach of the international arbitration clause, in order to essentially protect the international arbitration clause, and so that a party's choice of arbitration is respected and properly protected. I won't say very much about this slide. Simply refers to, again, Germany and Switzerland have also got very similar procedures in terms of enforcement, and in respect of bringing the New York Convention, upholding the New York Convention, and also the ICSID Convention. You will find this data in our Global International Arbitration Guide. You can see a list of the bilateral investment treaties with which the UK has entered into. This is, you can see the list is fairly extensive, and it's fairly significant because it shows the UK, when structuring your investment vis-a-vis the UK, you do get a fair amount of protection from many treaties with many different countries, which shows that your investment might get treaty protection under international law, with reference to depending on whether the ICSID Convention has been ratified by the other country, and also investment treaty protection under the ICSID Convention. But that shows you the breadth of protection that you would get vis-a-vis structuring the investment from the UK, and that is significant because we are going to talk in a minute about the Achmea decision and its impact in terms of protecting investments within the EU. Well, you can see in these slides the number of bilateral investment treaties. There are over in Europe. There are over 1,352 bilateral investment treaties. However, over 218 of them are intra-EU bits. And there are over 1,168 bits, bilateral investment treaties between EU and non-EU states. And the purpose of this slide is to talk about the Achmea decision, which has come out this year. In March 2018, the ECJ issued a decision that arbitration clauses in many bits are incompatible with EU law, and they raised concerns about the validity of the intra-EU bits and the Energy Charter Treaty. This is fairly dramatic because there is extensive, there are extensive investment treaty cases between parties from different EU states, and the idea that these would be incompatible with EU law, it would cause a massive hole in terms of the protections that parties would have within Europe. However, despite the fact that these treaties exist, the European Commission then clarified in July that all EU bits, it applies to the Achmea, the view decision applies to all EU bits, although in August 2018 there was a decision issued that it didn't apply to Energy Charter treaty cases, but as we will see further on, the prevailing view is that the effect of the Achmea decision is that intra-EU bits cannot be relied upon, and that is a major change from the position as it was before. As we saw earlier, there were 218 treaties, intra-EU treaties, which effectively the protection in them would be rendered redundant. So that is a major development in terms of arbitration in Europe. And as you can see on this slide, the fallout of Achmea continues. The German Federal Court sets aside an award in Achmea on the basis of the March decision that we saw earlier, and you can see that in the United Utilities case and the Republic of Estonia, the tribunal allows the EC to intervene as a non-disputing party in that arbitration. So the trend is therefore clear, essentially to stop intra-European arbitration seeking protection under the BITS. This is a major departure from the position before. But what does it mean in terms of the UK and the EU? If the UK leaves the European Union, that remains still in as everyone knows, that's still yet to happen. If it does, then contrary to the position that applies as a result of Achmea in other European countries, if you structure your investment vis-à-vis the UK, you will continue to benefit from protections under the treaties. So this would be, it is seen as potentially another advantage in favour of London and in favour of the UK, because in that way you will continue to benefit from investment protection under the EU treaties. And finally, in relation to the fallout of Achmea, there was a declaration that was issued by EU member states in January 2019. Interesting, the UK also undertook to terminate its intra-EU bids, but that it remains unclear whether that position is in anticipation, assuming that the UK remains in the EU, or whether how it takes into account the Brexit position. But it is very much remains hoped if there is a Brexit and the UK does leave the EU, that it will then be able to benefit from these EU bits. Finally, the English court's approach in favour of arbitration can be seen in the Halliburton decision v. Chav Bermuda, where in that decision, which may go yet to the Supreme Court, the issue was the interplay between English arbitration law and the law which is to be found in the IBA rules of conflict. The English arbitration law was applied in a sense to take into account a much stricter, much narrower approach in terms of looking at arbitrator bias. The Court of Appeal looked into and applied an objective test, a narrower test, and disregarded what can be found in the IBA rules on conflicts, therefore upholding the fact that it considered the arbitrator as being impartial. It therefore, I believe, further shows that the court is there, very much there, to support arbitrations and only intervene in fairly extreme circumstances.
Thank you very much, Raid. So let's then continue in Europe. I will start by referring to the jurisdiction where I am based, France, and in particular to Paris, which is one of the most popular arbitration seats, second according to Queen's Mary survey mentioned by Raid earlier, but of course it depends on what year the survey is done. And one of the reasons for the popularity of Paris as a seat of arbitration is the fact that it is the home, since its foundation in 1923, to the ICC Arbitration Court, no doubt the most popular arbitral institution worldwide. In fact, although its headquarters are in Paris, it cannot be described as a French institution, but as a truly international one. In recent years, the ICC has opened offices in New York, Hong Kong, Sao Paulo, and Singapore, from where it administers cases. To give an idea of its international scope and size, the ICC registered 810 cases in 2017, with parties from 142 countries. It had 104 different arbitration seats in 63 countries. There are other arbitral institutions in France, such as the Paris Center for Mediation and Arbitration, the CMAP, and the Association Française d'Arbitrage, but these are clearly more domestic in scope. For instance, only 9% of the 305 cases of the CMAP were international last year. Not much needs to be said about France in respect of enforcing foreign arbitral awards. France is well known for being one of the most arbitration-friendly jurisdictions, both for holding arbitrations in its territory and also for enforcing foreign arbitral awards. For that reason, it is one of the preferred jurisdictions when it comes to enforcing arbitral awards. It is a party, France, to the New York Convention and to the ICSID Convention. In addition, its Code of Civil Procedure, which includes France's arbitration law, contains a very liberal pro-enforcement regime. In fact, French courts are among the first which provided for the enforcement of arbitral awards set aside by the courts of the CID in the famous North Solar case in 1984 and Hill-Martin case in 1994. The basis for this is Article 7 of the New York Convention, which provides for the application of any regime which is more favorable to enforcement, and Article 1520 of the French Code of Civil Procedure, which does not include the set aside of the award in the place of its seat as a cause for refusing enforcement in France. Therefore, it cannot be taken for granted that an award annulled or set aside in its seat will not be enforced in France. French courts often issue interesting decisions, which are often innovative and closely followed by the international arbitration community. I would like to mention three judicial decisions from last year. The first one is the Société MK Group versus Onyx, in which the Court of Appeal of Paris set aside an award on grounds of public policy as it considered proven that an administrative authorization to exploit natural resources in the Democratic Republic of Laos had been obtained by means of fraud. This decision confirms an extensive interpretation of what international public policy is when it comes to France, and confirms the powers of the French courts in this respect. In the Republic of Moldova versus Comstroy case, the Cour de Cassation, the Cassation Court, overturned a decision of the Court of Appeal which had set aside an award under the Energy Charter Treaty. The Court of Appeal had considered that a debt arising under an electricity supply agreement was not an investment under the ECT Treaty, as it does not involve a transfer of capital or resources. The Court of Cassation, however, reversed this decision as it considered that the Court of Appeal had added a condition that was not present in the ECT, in the treaty. Finally, the Apax versus Technimont case, the decision issued last year by the Court of Cassation, is the last of a very long saga in a dispute which runs since 2007. The Court of Cassation confirmed in this latest decision that only serious doubts in respect of an arbitrator's independence justify setting aside the award. The 30-day period to bring a challenge has to be respected, and if new facts are discovered after this 30-day period has expired, these new facts must be sufficiently serious in themselves to be invoked, and not just a development of facts which were known earlier. Well, before moving to Latin America, I would like to stop briefly in Spain, my jurisdiction of origin, which is seen by many as a bridge between Europe and Latin America. My first comment in respect of enforcement of arbitral awards is that Spain is also a party to the New York Convention and to the ICSID Convention, and that the Spanish courts routinely enforce foreign arbitral awards under these two treaties. Further, the Spanish arbitration law of 2003 is a modern law based upon the USMCA model law, which provides for a simplified regime for enforcement of arbitral awards. In respect of arbitral institutions, I would like to mention the Madrid Court of Arbitration, in my opinion, the leading arbitral institution in Spain, which handles approximately 120 cases every year, around 20% of which are international, and many of them related to Latin America. Another institution worth mentioning is the Spanish Arbitration Court, also based in Madrid. However, the most interesting recent development is that these two institutions, together with a third one called Civil and Commercial Arbitration Court, also in Madrid, have signed a protocol to create a joint institution which could handle all international matters. This will mean that once this protocol is implemented, these three institutions will operate as a single institution in respect of international matters, while they will continue working separately in domestic cases. This will no doubt make Spain a more attractive place for international arbitration. Okay, then let's cross the pond and travel to Latin America. Latin America is a loosely defined region, generally including Spanish and Portuguese-speaking countries in Central and South America and the Caribbean. It is difficult to generalize given that the economic and political realities of each of these jurisdictions are different. In any event, I will try to refer to some general features and trends in the region in respect of international arbitration. So let's start by arbitral institutions. The leading arbitral institution in Latin America is actually the ICC. In fact, between 12 to 18% of parties in ICC arbitration, the percentage changes every year, generally come from Latin America, making it one of the most important regions for this arbitral institution. Many of those parties are Brazilian, and this is one of the reasons why the ICC recently opened an office in Sao Paulo. However, Latin American matters not related to Brazil are still handled from the ICC's headquarters in Paris. The opening of this office in Sao Paulo is, in any event, a very significant development for the region. In recent years, however, we are seeing the growth of local arbitral institutions, which more and more handle not only domestic but also international matters with high standards of quality. In Colombia, I would highlight the Chamber of Commerce of Bogotá, which hears both domestic and international matters and has run almost 1,500 cases over the period of 5 years running from 2010 to 2015. In Brazil, I would say that the most prominent institution is the Brazil-Canada Chamber of Commerce of Sao Paulo. It is not the only one, but perhaps is the one handling a higher number of cases. In 2017, it ran 141 cases. In Chile, I could mention CAM Santiago, the Chamber of Commerce of Santiago, which does not only handle commercial disputes, but has been identified by certain states of the region, such as Ecuador, as a potential venue for investment disputes. It has handled over 1,500 arbitrations since its launching in 1992. And finally, in Peru, I would like to mention the Chamber of Commerce of Lima, the Arbitration Center of the Chamber of Commerce of Lima, CCL, which handles a very large number of cases. It registers approximately 300 cases per year, partly as a consequence of the fact that in Peru, all contracts with the state or state entities are mandatorily to be submitted to arbitration, and this has created a very strong arbitration practice in Peru. So let's continue by talking about enforcement of arbitral awards in Latin America. All Latin American states are signatories of the New York Convention. You have a list in your screen of the countries of the region which have signed and ratified this convention. Accordingly, they all have in place a standard legal framework for the recognition of foreign arbitral awards. In addition to this convention, the Inter-American Convention on International Arbitration, also called the Panama Convention, adds an additional layer for securing enforcement of arbitral awards in the region. Further, most Latin American states have modern arbitration laws based upon the UNCITRAL model law, which provides for conduction of arbitral proceedings in their territory and recognition and enforcement of foreign arbitral awards. The latest states which have passed arbitration laws have been Argentina and Uruguay, both in July 2018. The Argentinian case is particularly important, given that it is one of the largest countries in the region and it had a very old arbitration law. It is in fact expected that with this new law, will eradicate judicial attitudes which were contrary to arbitration, which had developed in past years. And as a consequence of this change, of this new law, Argentina will become an important arbitration center in the region. A similar process was successfully implemented by Brazil in recent years, and Brazil evolved in a short period of time from being a jurisdiction where sometimes there were found attitudes against arbitration to a very pro-arbitration jurisdiction. More good news come from Ecuador, which in 2018 repealed legislation which included requirements in addition to those of the New York Convention from recognizing arbitral awards against the state or the state entities. Nowadays, thanks to this change in legislation, only the requirements under the New York Convention need to be complied with. The situation remains complicated in Venezuela, where despite the existence of a modern arbitration law, the judiciary lacks independence and often does not respect arbitral tribunals, and also in Bolivia, where the arbitration law restricts matters which may be submitted to arbitration, excluding, for instance, natural resources, and also limits the possibility for the state or the state entities of submitting to arbitration unless the seat of the arbitration is located in Bolivia. So let's now turn to investment arbitration, which in Latin America has been widely used. In fact, states such as Argentina, Venezuela, or Bolivia have been among the most frequent respondents in investment arbitration due to certain of their policies in past years. The dissatisfaction caused by the investment protection system has provoked a reaction contrary to investment arbitration by certain countries. As a consequence, Bolivia, Ecuador, and Venezuela denounced the ICSID Convention in recent years, being actually the first states in abandoning this treaty worldwide. At the other end of the spectrum, Mexico actually ratified the ICSID Convention in 2018. Latin American states have subscribed numerous bilateral investment treaties, both between themselves and with third states. In fact, there are 337 BITs signed between Latin American states and non-Latin American states. Three facts need to be remarked, however. The first one is that the first economy in the region, Brazil, has never ratified any BITs nor the ICSID Convention. Since the 1990s, Brazil opted for an investment protection policy not based on the framework of BITs or on the framework of international arbitration. Only in recent years, Brazil has entered into a new type of bilateral treaties on facilitation of investments with certain African and Latin American states. This set a framework for the promotion of investment in Brazil or in the other signatory state, but does not allow submitting disputes between investors and states to arbitration. The second fact is that the dissatisfied states mentioned early, or some of them, have also denounced their bilateral investment treaties. This is the case of Bolivia and Ecuador, which denounced all of their treaties. In the case of Ecuador, the denunciation of the latest of these treaties took place very recently. Most of these treaties are now in the sunset period, which is a period of 10 to 15 years, depending on the treaty, during which they remain applicable for investments made before their denunciation. However, Ecuador has changed once again its policy and is now seeking to enter into a new generation of investment protection treaties through a new model that has been prepared by the government of Ecuador, which actually intends to curtail the protections offered to investors. Finally, Venezuela has also denounced at least one of its BITs, the BIT with the Netherlands. Well, the CPTPP, or the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, is a multilateral free trade agreement for the Pacific region, which contains an investment protection chapter. In Latin America, Chile, Mexico, and Peru are signatories of this treaty. Mexico has already ratified it, while Chile and Peru are yet to do it. Colombia has expressed interest in joining this treaty. This treaty also became very popular when the United States abandoned it after having signed it after the election of Donald Trump as president. Canada, however, has already ratified this treaty. As I said, this treaty contains an investment protection chapter which provides for narrowed ISDS provisions, which essentially are aimed at protecting the right of the states to protect public interest and maintain the right to regulate in these matters. And finally, I will refer very briefly to a couple of interesting key recent decisions on arbitration issued by local courts in Latin America. The first one is a recent decision of the Sao Paulo Supreme Court of Justice, which actually allowed extending the arbitration agreement that was contained in the main contract to other ancillary contracts that had been signed and which did not contain in any dispute resolution agreement. This decision, of course, opened the doors to extending the arbitration agreement on the basis of tacit consent to related transactions. And the second of the decisions I would like to mention is the Consorcio Ferrovial versus Carbones del Cerrejón, where the Supreme Court of Colombia confirmed the restrictive scope of the set-aside procedures. And this is quite important because this is issued after Colombia passed in 2012 an arbitration law based upon the UNCITRAL model law, and confirms that the courts cannot actually revisit the merits of the dispute. This shows a very strong commitment of the Colombian judiciary in favor of international arbitration. So this is all for Latin America. I will now leave the floor to my colleague Soledad O'Donnell, who will go north and will discuss developments of arbitration in North America.
Thank you, Alejandro and Raid. So turning to the U.S., in the U.S., there are generally 5 institutions that are frequently utilized. These are by no means an exhaustive list of the institutions, but generally one of the most popular institutions is the American Arbitration Association, frequently referred to as the AAA. The AAA was formed following the enactment of the Federal Arbitration Act, which I will mention more about shortly. It primarily focuses on commercial, construction, employment, labor, government, and consumer, but these are domestic disputes, which is critical to point out here since we're speaking about international arbitration. The AAA, however, has an international arm, and that's our second arbitral institution listed on this slide. It's the International Center for Dispute Resolution. And one of the institutions that we've referred to now numerous times is the ICC, the International Chamber of Commerce. It's the leading international commercial arbitration institution. It's one of the most utilized in the U.S. As Alejandro mentioned, there are over 950 cases a year involving about 3,000 parties from 137 countries and territories. There's also the Institute for Conflict Prevention and Resolution, often referred to in the U.S. as a CPR. The CPR aims to reduce the cost of litigation by encouraging in-house counsel and their law firms to pursue alternative dispute resolution methods before filing a lawsuit. And finally, JAMS. JAMS handles about more than 14,000 cases a year through a myriad of alternative dispute resolution methods, such as arbitration as well as mediation. It focuses on domestic disputes as well as international disputes. JAMS formed JAMS International through affiliated centers in Italy, Spain, Egypt, and China to expand its global reach. Mayor Brown's arbitration practice not only deals with disputes themselves, but there's also an advisory role to our practice where we assist clients that are entering into agreements to determine the best method of dispute resolution for their particular matter. And so part of that advisory role is assisting clients in drafting international arbitration clauses and to determine whether international arbitration is a method of dispute resolution that they should pursue in their agreements. Frequently in the U.S., we emphasize the many advantages of international arbitration, particularly the neutrality of the forum, the sophistication of the decision makers, as well as the flexibility of the process that many of you are well aware of, in particular the ability to select the choice of law, the seat, and for example, the number of arbitrators. But arguably the most important advantage to international arbitration is the enforcement mechanism available for arbitral awards that Raid and Alejandro have mentioned in their portion of the presentation as well. In the U.S., that is available through the New York Convention, which we've spoken about several times throughout the presentation. The New York Convention requires contracting states to, 1, give effect to private agreements to arbitrate, and 2, recognize and enforce arbitration awards in contracting states. Currently, there are approximately 160 contracting parties to the convention. In the U.S., there's also the Panama Convention, which Alejandro mentioned in his presentation as well. In the 1970s, many Latin American countries refused to sign on to the New York Convention, although that has since changed, as he mentioned. In response to that, the U.S. adopted the Panama Convention to promote international arbitration in Latin America. The convention provides enforcement of awards in more than 15 countries in the Americas, including the U.S. And finally, one thing that's worth noting, which has also been mentioned, but generally, although these conventions are critical, it is not necessary to rely on them, as the majority of awards are complied with voluntarily. This speaks highly, or it's an additional way of showing how successful international arbitration is. However, having these mechanisms, these two conventions, for example, on which to rely on is critical for many of our clients. In the U.S., courts are generally very deferential to arbitration and enforce arbitral awards. This is in large part because the convention, the New York Convention, sets out very narrow grounds on which a party may resist enforcement of an arbitral award. Article 5 of the New York Convention sets out grounds on which a party may rely on to resist enforcement. These include incapacity of a party or the arbitration agreement is not valid under the law that the parties are subjected to or under the law of the country where the award is made, failure of due process, for example, if there was not given proper notice of appointment of arbitrators or the party was otherwise prevented from presenting its case. Similarly, if the tribunal exceeded its authority or jurisdiction. Composition of the tribunal was not in accordance with the agreement of the parties or under applicable law. And finally, if the award has not become binding on the parties. Article 5 of the New York Convention also sets out additional grounds on which recognition and enforcement of an arbitral award may be refused. Specifically, if the competent authority in the country, i.e. the court where recognition and enforcement is sought, finds that the subject matter of the dispute is not capable of settlement by arbitration under the law of that country, or the recognition or enforcement of the award would be contrary to the public policy of that country, then the court may refuse enforcement. Article 5 of the Panama Convention sets out similar grounds for non-recognition of an arbitral award. Enforcement of international arbitration awards under U.S. law is governed by the Federal Arbitration Act. Section 201 of the FAA implements the New York Convention into U.S. law. Section 207, as listed here on the slide, of the FAA states that within 3 years after an arbitral award falling under the convention is made, any party to the arbitration may apply to any court having jurisdiction for an order confirming the award. As I mentioned earlier, U.S. courts are highly deferential to arbitral awards. The FAA is explicit in this regard. The FAA states that the court shall confirm the awards unless it finds one of the grounds for refusal or deferral specified in the convention, which, as we just discussed, are very narrow grounds. Similarly, Section 301 of the FAA implements the Panama Convention into U.S. law. Similar to Section 207, which we just saw in the last slide, Section 304 gives little room for courts not to enforce those awards. Section 304 states that arbitral decisions or awards made in the territory of a foreign state shall be recognized and enforced. The U.S. is party to 45 bilateral investment treaties, 6 of which are not yet enforced. 2 bilateral investment treaties have been terminated. The U.S.-Bolivia and U.S.-Ecuador treaty, as Alejandro mentioned, are no longer in force. As also mentioned, bilateral investment programs help to promote private investment and to develop market-oriented policies. The Office of the U.S. Trade Representative lists 4 general characteristics of U.S. BITs. 1, they require investors and their covered investments to be treated as favorably as the host party treats its own investors and investments. 2, they generally establish clear limits on expropriation of investments and provide for payment of prompt, adequate, and effective compensation when expropriation takes place. 3, they provide for transferability of investments related to funds in and out of the host country without delay. And 4, and as we've discussed, in the U.S., it is generally elsewhere, a key feature of bilateral investment treaties is that they give investors from each party the right to submit an investment dispute with the government of the other party to international arbitration. One key trade agreement that was in the news late last year and arguably dominated news coverage is the USMCA, or what is often referred to as the new NAFTA, the U.S.-Mexico-Canada agreement. In September of last year, following intense negotiations, U.S., Canada, and Mexico reached an agreement on an otherwise revised version of NAFTA. The USMCA is pending ratification by each country's legislatures. If ratified, however, the deal would, among other key features, 1, eliminate investor-state dispute settlement arbitrations between Canadian parties invested in the U.S. and vice versa. 2, limit U.S.-Mexico investor-state settlement arbitrations. The USMCA, for example, limits investors from asserting certain claims, such as certain indirect expropriation and discrimination claims, and provides certain provisions for certain sectors, such as the oil and gas, power generation, and telecommunication, among others. And 3, continues anti-dumping and countervailing duties arbitration. Anti-dumping cases are generally used to block imports on the basis that the exporting country is not trading fairly. For example, by subsidizing a domestic industry so it can lower prices. NAFTA's binational arbitration process for resolving disputes over anti-dumping and countervailing duty measures remains in place in the USMCA. I want to highlight today 3 key recent court decisions in the United States, 1 coming out of the United States Supreme Court and 2 coming out of the Second Circuit, which is a circuit that oversees New York. The first, Henry v. Schein, is a U.S. Supreme Court decision issued earlier this year. The issue in that case was whether, per the terms of the parties' agreement, the arbitrators had the power to resolve arbitrability questions. That is, whether an arbitrator or the court should decide whether the dispute should be decided via arbitration. The court in that case held that under the FAA, arbitration is a matter of contract, and the parties to such contract may agree to have an arbitrator decide not only the merits of a particular dispute, but also gateway questions of arbitrability. The court found, therefore, that if the parties to a contract delegate the arbitrability question to an arbitrator, it may not override the contract, even if the court thinks the arbitrability claim is wholly groundless. This further highlights U.S. courts' deference to the parties when agreeing to arbitrate. The second case, the Lloyd's of London case, is a Second Circuit case decided last year. The issue in that case was whether the standard for evident partiality should be the same for a neutral arbitrator or a party-appointed arbitrator. The court in that case held that when the parties desire arbitrators with expertise and do not require neutrality, under certain circumstances, undisclosed relationships with a party are insufficient to authorize a court to vacate an award. There are certain exceptions, however, to the court's holding. A party may continue to successfully vacate an award if the undisclosed relationship either violated the requirements laid out in the arbitration award or prejudicially affected the award. And finally, General RE Life Insurance versus Lincoln National. That's also a Second Circuit case decided last year. In that case, the court examined the functus officio doctrine, which states that once arbitrators have fully exercised the authority to adjudicate the issues submitted to them, their authority over those issues is ended, and the arbitrators have no further authority absent agreement by the parties. The court in that case held that an arbitrator does not become functus officio when it issues a clarification of award, so long as 3 conditions are satisfied. 1, the award is ambiguous. 2, the clarification merely clarifies the award rather than substantively modifies it. And 3, the clarification comports with the party's intent as set forth in the agreement that gave rise to the arbitration. This case, again, further highlights the court's desire to support arbitration and continue to support the efficiency of the process. This concludes our webinar on how to navigate international arbitration in the Americas and Europe. We hope the information shared was useful. If you submitted a question that was not answered, we will follow up with you directly. Should you have any additional questions related to today's topic, please email them to Annie Keating at akeating@mayorbrown.com, and your questions will be promptly forwarded to the speakers. Thank you very much for your participation.